Order. Pledge allegiance. Indivisible, with liberty and justice for all. The prayer this afternoon will be given by the good delegate from Baltimore County.
Thank you very much, Madam Speaker. Please join me in prayer as we stand here in our hallowed chamber. Many of us are at the Cathedral of Camden Yards in our minds. If not wishing, it will be there in person and sometime soon. As we consider the titans of that venue, let us think of the batted balls they will handle in the field in the same way that we handle what is hit at us and our bills. We, like them, have the hardline drive hit at us. We must react quickly or it will get by us. We, like them, have the slow roller. We must charge directly at it, pick it up quickly and make the play. We, like them, have the foul ball. It may seem out of play for now, but a good pursuit just might result in unexpected success. We, like them, have the outfield fly, the veritable can of corn. It will get there in its own time, just lazily. Just relax and play it slow. And we, like them, have the home run ball. It could disappear into the night and never be seen again. But sometimes a good leap at the wall, a Herculean effort can bring it back. So we still track it. No matter the outcome of the play, we know we will give it our best in the field. Help us to stay on point these last days. Amen.
Amen. Quorum call.
Madam Speaker.
Has everyone recorded their presence?
I got her.
And so the clerk will take the call. There being 132 members present, the House is now in session. The clerk will read the journal from the previous day.
Annapolis, Maryland, March 28, 2023.
Recognizing Deputy Majority Leader.
Thank you, Madam Speaker. Move so much be considered the reading of the journal.
So order, petition, memorials, and other papers. Report of the Committee on Judiciary, report number 35. Clerk will read the bill.
Senate Bill 1, Criminal Law, Wearing, Carrying, or Transporting Firearms, Restrictions, Gun Safety Act of 2023. Favorable amendments. Amendment 1.
Recognizing the chair of the committee.
Thank you, Madam Speaker. Move so much be the reading of the amendments.
So ordered.
Amendment number 1 is technical. Amendment number 2 alters the specified areas and locations under the bill where a person is prohibited from wearing, carrying, or transporting a firearm. It alters certain definitions under the bill and alters and clarifies the exceptions under the bill. Amendment number 3 requires a specified government or public infrastructure area to display a certain sign. It alters the penalty provisions and strikes certain provisions relating to transporting a firearm in a motor vehicle. Amendment number 4 adds an exception to the bill related to the authority of an administrative head of a Maryland court. Amendment number 5 alters provisions of the bill relating to the wearing, carrying, and transporting of a firearm on certain property or in certain dwellings without permission from the owner or the owner's agent. Amendment number 6 strikes a provision under existing law related to the authority of the Secretary of the State Police and limitations on handgun permits and makes a conforming change. It strikes provisions of the bill altering the qualifications and requirements for the issuance of a handgun permit. It strikes provisions altering the requirements for revoking a handgun permit and strikes language altering certain notice requirements. And it strikes language altering certain reporting requirements and makes technical changes. Move the amendments.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Aye. Opposed? The ayes have it. The amendments have been adopted. The question now is adoption of the favorable report as amended. All in favor signify by saying aye. Aye. Opposed? The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill or to its title? Recognize the gentle lady from Baltimore County.
Thank you, Madam Speaker. Would the floor leader please rise for a few questions?
Chairman of the committee.
Thank you.
Thank you so much. Good afternoon.
Good afternoon.
This is, as you know, a very, very important bill to all of us on the floor with some constitutional ramifications. And so I have a few questions as I'm reading through the bill line by line, starting on page 4 of the reprint. And line 15, in this section, the following words have meanings indicated. I'm wondering about the line 19, a private primary or secondary school, or the grounds of the school. So why did you all select or decide to leave that in?
So that was in the Senate bill, and it was in the bills, I believe, as introduced. Well, not as introduced, actually, because it was completely different as introduced in the Senate. But it's broken into three parts, the sensitive areas. The second part are government buildings, and since a public school is a government-owned building as opposed to a private school, which isn't, that's why we kept those two separate.
So disregarding their rights of a private school to determine their own rules, we'll see later this forbids anyone from carrying a firearm on a private school ground.
Subject to the exceptions that are in the bill.
Okay. The next question would be on the healthcare facility as described in on line 22. Can you tell us what places those are, those healthcare facilities?
They would include a hospital, the associated buildings of the hospital, my brain just stopped. The ambulatory surgeries as well, or walk-in surgeries, and places for people with disabilities to go to get rehabilitation.
Okay, thank you. And moving on to page 5 of the bill, it talks about on line 17, a location licensed to sell or dispense alcohol or cannabis for on-site consumption. Can you let us know, is that every restaurant, every marina, every...
If they have a license to sell alcohol, they would be covered under the bill, yes.
So
If they have a license to sell cannabis for on-site consumption, that may be a bill we're hearing later, yes, that would be also covered under the bill.
And how about a private home where somebody has a one-day liquor license?
A one-day liquor license would imply that they were selling the alcohol, but if they were somehow getting a one-day liquor license to sell the alcohol at their home, which would be odd, then they would be caught under this. Having said that, all situations where they get a liquor license, whether it's one day or forever, would be covered under the bill.
Yes, it says or dispense, so even if they were not selling it, if they were serving it, it would prohibit because the language says or dispense. And I see that you took some things out, like line 27, a fair or carnival,
It,
and you left racetrack in. Why is that?
we left racetrack. It's the language that came from the Senate. We also left casinos, which is the next area, the video lottery terminals.
And how about amusement?
Video lottery facility, I'm sorry.
And amusement parks?
Amusement parks are still in. Fairgrounds were ultimately taken out of the bill. There was a discussion about whether fairgrounds should be in or out, and they came out.
Okay, fairgrounds are out, but amusement parks are in.
Yes.
Okay. And then moving on to page 6, there's language about law enforcement officers, police officers, law enforcement officials. And so can you describe to us who then is allowed to wear and carry a firearm, please?
So there are a number of exceptions that are in the bill, and you can read them in the reprint, but I'll go through them now. A law enforcement official or a police officer, those are defined terms, and there are people who are considered both a law enforcement official and or a police officer that are in other parts of the code.
Does that include EMTs?
I don't think that an EMT is a law enforcement officer, but I'm happy to double check, and I'm sure we'll be talking about it more. They're not.
Okay.
A member of the armed forces, I skipped one, an on-duty employee of a law enforcement agency authorized by the agency to possess firearms on duty, whose duty assignment involves the possession of firearms. This could be somebody who does test fires of guns. This could be somebody who does evidence collection. This could be somebody who works for the law enforcement agency and needs that ability. A member of ROTC while participating in an ROTC program, a correctional officer or warden of a correctional facility in the state, a railroad police officer, an employee of an armored car company. And then we get into language regarding law enforcement officers, and particularly law enforcement officers who have retired. So they're law enforcement officers who have retired, who are covered in part by federal law, so we include that language. That actually was language that we accepted as an amendment in the committee, and that language is there on page 6 in subsection 8. Goes on to, so those are the exceptions to the rule.
Okay, thank you, Chair. Then continuing on on line 30, 31, and 32, just above it, an official or person is carrying the official's badge or credentials, so they obviously need to be carrying their credentials if they're law enforcement carrying a firearm. But then the next section 2, a firearm carried or possessed by the official or person is concealed from view. So they have to conceal their firearm. They can't carry it on their hip. A law enforcement officer, I'm a little confused on
That's
this.
the language that came from the Senate and the language that we kept in the House, that the weapon needs to be concealed.
Even for a law enforcement officer. So if a law enforcement officer, obviously they can they should open carry while they're on duty, clearly. We want law enforcement officers
That's for retired officers, actually.
It's only for retired on
Yes,
concealed, but not
and
off duty. Does it include off duty as well?
Yes, it does.
So
Double checking.
when a law enforcement officer is going to and from work, do they then have to conceal their firearm?
They wouldn't have to. If they were going to and from work, then they would be in their car, and they would not have to conceal their firearm while they were in their car driving to and from work.
Sure, but if they had to stop at the supermarket and pick up a dozen expensive eggs, would they have to conceal that?
If so, they would be off duty, so yes, they would have to conceal their firearm.
Okay. That's interesting, that there's no provision to allow them to get to and from work, because clearly we don't all just go right home from work. You have errands that you have to run. Moving on to page 7, I see on lines 26 to 30, was that stricken, the firearm that is carried or transported in a motor vehicle?
That was stricken by an amendment. There are further conversations that are even happening now among committee members to address an issue that has arisen because of that. And the committee will be taking up, I think, a committee amendment tomorrow in the morning to address an issue related to whether people or not would be able to, how people would store firearms in the vehicle.
Great, thank you so much. Because we know there's certain limitations today for people who don't have wear and carry about safely transporting your firearm to and from the range and whatnot.
The goal would be to address those people with permits, not
right.
the people without permits would still have to transport them in the ways that are already prescribed by law.
Certainly, yes, thank you. Then moving on to page 8, on lines 22 to 24, a conviction under this section may not merge with a conviction for another crime. Can you explain to us what that means?
That's it addresses an issue related to the rule of lenity that says that if two crimes are roughly similar in their elements, that if they have two different penalties, and in this case there would be, from the penalty for somebody who wears and carries without a permit at all would have a 3-year penalty. someone who has a someone who would violate the spaces part of the sensitive places part of this legislation, it's subject to a 1-year penalty. The goal would be to make sure that, and the way we believe we've drafted it, is to ensure that somebody who has a wear and carry permit would be only subject to the 1 year as opposed to the 3-year penalty.
So would this penalty then, if it was an accidental violation of this complicated law and they accidentally violated that, would this then mean that they could never wear and carry or possibly own a firearm after that?
No.
It would not. Okay, thank you. The next part that I think is of highest interest to many of us is on page 9, and it's 6-411, where it starts talking about dwelling and talking about what a dwelling means. So the mile-high vision on the dwelling is limiting where someone with a wear and carry permit may wear and carry as it relates to private dwellings. Is that right?
Yes.
Okay. So it says a building, a part of a building that provides living or sleeping facilities. So I think the rest of that page goes on to define what a dwelling is. And then over on page 10, it talks about shared dwelling, but also talks about on lines 2, 3, and 4, portion of real property subject to an easement, a right-of-way, a servitude, or another property that allows public access on or through the property. So, going a little further, just to give this context, a person who has a wear and carry permit is not permitted to carry their firearm on these upper defined easement, right-of-way, etc., unless they have the permission of the owner. Is that correct?
The section that you just read is actually in the exception section to the dwelling definition.
Okay,
so that doesn't apply to an easement.
Okay, so I, for instance, share a driveway with my neighbor.
Correct.
So that driveway is fine. An easement, a right-of-way, you don't have to get special permission. So if a friend comes to visit me who has a wear and carry permit, they're not impacted by coming down my driveway. That's an easement.
Unless you sleep in the driveway, no.
Unless, I'm sorry?
Unless you sleep in the driveway, no.
Yes, I don't. Okay, thank goodness. Not today. Thank you.
Because that goes back to the definition of dwelling.
Okay.
That it specifically is talking about the building where people sleep. It's not talking about the yard around it. Unless you sleep in the yard, it's
okay. Thank you. I'm
it
glad
could go on for a while.
Yes, thank you for clarifying that. We're not encapsulating, in getting people's driveways involved in this. Down on lines 13 and 14, a person wearing, carrying, or transporting a firearm may not enter or trespass in the dwelling of another unless the owner of or owner's agent has given express permission either to the person or the public. So does that mean a person with a wear and carry permit can't go on anyone's property unless they know that they have permission to go there?
You're talking about which section in 13?
C, paragraph C.
A person wearing, carrying, or transporting a firearm may not enter or trespass in the dwelling of another unless the owner or owner's agent has given express permission either to the person or to the public generally to wear, carry, or transport a firearm inside the building. So what we said is that if this is your house, if this is where you live and this is where you sleep, that the person, if they want to wear and carry inside your house, they have to have your express permission.
And if you do not know whether you have permission or not, then the wear and carry permit owner is to say they do not. Is that what it's saying?
Correct. For example, if somebody who was working for a business and perhaps was doing work inside your home came to your home and it was a person who was concealed carrying and they didn't check with the homeowner, which of course I think all of us would hope that they would check with the homeowner whether it was okay for them to bring a gun inside the house. Having said that, if they did not ask for specific permission and get the specific permission, they would be in violation.
Can I ask why you didn't take the converse, which would just say that if a person did not want someone to wear and carry on their permit, they would post, "You may not." Instead, the committee took the other approach, which would be, where the sign, let me clarify, the onus would be on the property owner to say, "You may not wear and carry on my property." Instead, we're saying the wear and carry permit owner is to assume that you cannot carry at all unless that person has specifically said you could.
There are two parts to this part of the bill. There's the part with regard to people's dwellings, their houses, and there's the part with regard to other private property. And it goes to a broader discussion about where a person's right to wear and carry a concealed weapon runs up against another person's right to have control over their property and to be able to say, "No, I'm not going to allow you to come into my house." And so what we did and what the committee did is say, you must get their permission before you come into their house with a firearm in the case of a residence and, in fact, in the case of other private property.
Well, we know this bill is in response to the Bruin decision, and I think they had determined that there needed to be some historical context. So can you tell us where, what the historical context to this would be?
The Third Amendment.
Can you describe that in detail for us?
The Third Amendment was a part of the reason that the Revolutionary War happened in the first place, when British soldiers were quartered in people's houses, and people's houses were used, and people were forced to accept people with weapons inside people's houses. If there was one thing, for better or for worse, that people were very, very obsessed about throughout colonial America, and particularly in the Revolutionary era, it was their property and their ability to control their property. And that was one of the biggest things that they had to do with. So what I would say, the Third Amendment is a pretty big sign and a pretty big historical precedent in this case.
Except for that was at times of war, and those soldiers were potentially the enemy versus just another citizen.
But at the same time, it was expressed and clear that they were never going to be allowed into their houses, and they couldn't be allowed in times of peace either. Because I think it's posse comitatus, I think is the words that come to mind. But in any case, I think it would be difficult for people to look at the jurisprudence of the time, and certainly at it would be fundamentally difficult for people to say that private property was not something that individual colonial Americans were very interested in, and they were interested in protecting those properties going forward. And so I believe that there's a clear historical analog here.
Yes, I think this is the actual Third Amendment. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in manner to be prescribed by law. I would say that single mom who's carrying a firearm to protect herself is not a soldier in time of war, but I guess this is something the court will work out, because you would out-lawyer me every day. But, truly, you are a lawyer, and I just play when it works.
My goal genuinely isn't to out-lawyer. I'm trying to answer the question.
Yes, I appreciate that.
I think that the single mother, if they're going to someone else's house, someone else's property, would be absolutely right to say, okay, can I concealed carry inside of your property?
Yeah.
And I think that and I would say there were a lot of scenarios that were rolled out in the committee that were kind of interesting. I don't know that person at all, but now I have to call and get permission to find out if I can wear and carry inside the house. And it's like, well, yeah, you do.
Yes, I guess the courts will determine who's a soldier and who's not, and whether we're in time of war or not. Because I'm certain
have to find a historical analog. It doesn't,
right.
And the opinion very clearly says that there's not going to be a perfect line for anything in the Supreme Court's opinion.
Okay, thank you. Going down to lines 16, 17, enter or trespass on a property unless the owner or the owner's agent has posted a clear and conspicuous sign indicating that it is permissible to wear, carry, and transport. So, except for in the fact if they dispense alcohol. So if a restaurant had a sign that said, "You're welcome, welcome wear and carry permit owners, you can wear and carry your firearm in my restaurant." But if they dispensed alcohol, then even though they weren't drinking, because we already know it's illegal to drink while you're carrying your firearm. So how do these two relate together?
So it still would, the ban still exists on people wearing and carrying in a bar or in a place where you could consume cannabis. Should we allow that in what is another bill some other time? But having said that, yes, it would require on the private property front, it requires the place to put up a sign in a clear and conspicuous place. The committee also accepted an amendment to make it clear that it wasn't the parking lot that we were talking about of a place. It was the actual building that this would apply to, as opposed to any land that was around it.
And was there discussion in the committee about this specific sign and potentially creating a target for people that may want to, come or not come to that?
There have been discussions about signs both allowing and disallowing, and whether either sign could conceivably be a target or not for people. And I think you could get into a circular argument on both of them. So it comes back to, I think it comes back to the rights of private property owners to determine what they want to do and who they want to allow onto their property and not.
Okay, and there's a little more language on that, but I think it's clear. I did miss a question on page 5. Let me go back there. So the part that talks about any office at the top, lines 1 through 3, a building or any part of a building owned or leased by a unit or of state government. So if the government leases one office up on the 4th floor of a 6-story office building, does that then mean that the entire office building is precluded from people wear and carrying in that building?
No, our goal was to have it only be for the space that the government actually leased in the office building and not for the entire building.
Okay, maybe there might need to be an amendment because it says a building or any part of a building. I could see that being a little confusing, if the government, especially in the rural counties where, there is a county office somewhere that's in a larger building and, that the leasees of the rest of the building may not agree with that policy. So, thank you. Almost finished. Thank you, Mr. Chair, for indulging my questions so we can get a full understanding of this bill. And I'm super thankful that you struck out the language on the next many, many pages.
There's really nothing after page 10 that's still in the bill except for a severability clause at the end.
Okay, I think those are all of my questions. Thank you again for indulging. I know that we'll have a number of amendments and other questions from here. Thank you so much, Madam Speaker.
We'd ask for amendments. If they're going to be made available, please make them available to the committee as soon as you can.
And thanks, body, for indulging us. I know everybody's anxious to go root on the Orioles, but we do think this is important.
Madam Speaker.
Yes. Go ahead.
Thank you, Madam Speaker. Just a few more what-if questions, if the committee chair would yield.
Sure. Committee chair.
Live in a rural part of the state. We enjoy things like hunting and trap shooting and target practice. So I have a particular instance that I wanted to ask a few questions on, if you don't mind. Probably the first one would be, we actually, in Cecil County, located at Elk Neck State Park, and I don't think we're the only one. We have a shooting range that's located there on the state park that tend to frequent. So my question there is, if I do have a concealed carry, or even if I don't, and I want to go and use this facility, is it precluded in the way that the bill's written?
No, in the exceptions on page, I think, 8 or 7 of 20, it's in section 10, a location being used with the permission of the person or the governmental unit that owns, leases, or controls the location for an organized shooting activity for educational purposes, a historical demonstration using a firearm, or hunting or target shooting. So if you were target shooting there, then that would be covered.
Okay, and then the second part of that, in terms of the hunting, my understanding is that there is ability to approach game that's been wounded or been shot, even if it leaves the property that you have permission to hunt on and goes into a subsequent or adjacent property, that you can pursue that. Would one have to get, this permission that you've spoken of to go onto an adjacent property to retrieve game, such as a deer?
I don't know that there's anything in the bill specifically that addresses that issue.
Okay, and then, because you spoke earlier, I'm still trying to understand the nexus of inside a building versus on my property. So, if we could get some clarity on that.
I'm
a
sorry,
little
what's the
concerned.
question there?
So the question is, if I'm hunting on a property that I have
I'm
permission.
sorry. Okay, I got that. I didn't know if you had moved on. Sorry.
And then the other concern that I had, I believe it's on page 15. Does it still make reference to the 21 years old?
No. You're talking about language, I think, that has been struck. Yeah, it's been stricken. Everything after page, I think it's page, the middle of page 11 is struck, except for one of the sections at the very, very last page of the bill that has a severability clause.
Okay, so should this pass, someone 18 years or older could qualify for concealed carry?
That was in a different bill, the concealed carry in House Bill 824, which we passed already here and was sent to the Senate. It said that you had to be 21 in order to get a wear and carry permit.
Yeah, I know that there's some litigation pending on that, so I'm curious, but I want to stay on the bill. I guess, thank you for yielding for the questions here. My biggest concern is that, we're going to inadvertently create a new class of criminals, should this bill pass. There's so many instances in here where the average citizen who is law-abiding, who goes through the training, who pays the fees, who has a clean record, and affords themselves the ability to get a concealed carry, will now spend any and all time while they're participating in concealed carry concerned about whether they're creating a law infraction for themselves, subject to arrest, or able to travel to certain places. As someone who does have a concealed carry permit, I do not carry that often. This bill, should it pass as written, is very concerning. I think that I don't know why we need this bill. I don't think that people that are concealed carry permit holders are criminals, or that they participate in activities that lead to arrest. These folks have to have background checks conducted on them. They have to constantly relicense. There is a tremendous administrative burden as well as a behavioral burden that they have to occupy so that they can continue to have that concealed carry, and it can be revoked at any time. And I believe that they're being unfairly targeted in this bill. And if I'm reading the tea leaves on some of the things that are coming out of the Supreme Court decision and the lower courts, I think this bill obviously will be immediately challenged upon its passage. But I personally don't appreciate all of the great lengths that we're going to, in my opinion, to create a new class of criminals. Thank you, Madam Speaker.
Madam Speaker.
Madam Speaker.
Who was up first? Go ahead.
Thank you, Madam Speaker. Very briefly, if the chair of the committee would indulge me, just a couple of questions. As you know, we may have some amendments tomorrow on third reader. I'm a lot of bad things. I'm not a hypocrite. So when I say to you that A few weeks ago, I stood here and said that the constitutionality of a very important act, something I think that's made even more important by a report that was released the other day, we shouldn't be the final arbiters of the constitutionality of an enacted piece of legislation. I believe that. But I also know that we have to be somewhat cognizant of what courts are doing. If there are active litigation in the field and binding court decisions or persuasive court decisions, we should acknowledge those as we're trying to litigate here, or legislate, excuse me, at the same time. And I know that since the Bruin decision came down, several other states that were not shall-issue states but had limitations upon the granting of a concealed carry permit, they went back, their legislatures went back, and they attempted to refine or revise their laws in the way that we perhaps are trying to now, to place restrictions in light of the Bruin decision upon concealed carry. You're familiar with some of those efforts?
Some of them, yes.
Okay. And so it's my understanding, I'm trying to get credit, like the state of New Jersey attempted to do something somewhat similar, certainly not exact with what we're doing in this bill, but the state of New Jersey that was in a very similar posture to Maryland prior to Bruin, their legislature went back and enacted more restrictions, regulations on how you could get a concealed carry permit. My understanding is that has been, a preliminary injunction has been granted against that by the New Jersey federal courts pending appeal to the Third Circuit. I think I got my circuits there right. I think New Jersey's in the Third Circuit. I think New York's in the Second, the Third Circuit. And then is it also true that two separate New York federal district courts, because the state of New York where Bruin originated from, they have gone, New York attempted to come in with a lot of restrictions. Do you have much familiarity, stumbling there a little, over what New York's legislature did in response to Bruin with how they came out with restrictions for the concealed carry permits?
So I read the opinion. I don't have it with me, and I'm sure I'm going to need it tomorrow, but I will, I'll be sure to have it with me tomorrow. But I've read the opinion with regard to the Western District of New York,
right,
which I think was the initial
I think it was
response to the legislature's response in New York.
Okay. And so the New York legislature did things that I would characterize, at least, and hopefully wouldn't be mischaracterizing them, as somewhat similar to what this bill did. It continued with a variety of geographic restrictions, places that you could not conceal carry, both just as an absolute and also as a, you had to gain express permission before you could. And it seems to me, not being an expert in this field of law certainly, but it seems to me that the federal courts in New York have found, at least on a preliminary basis, that those restrictions cannot be implemented consistent with Bruin.
I would disagree with that, and I think that there were some restrictions that they did allow and some restrictions that they didn't in the opinion that I read. Mm-hmm. I do think, with no disrespect to the legislature of the great state of New York, that they were in some ways perhaps creative in their definition of one particular area that the court struck down, which I think was everything from Chelsea to Central Park. It was defined as Times Square, which was seen by the court as being excessive. I think what we have done as an alternative here is tried to be very specific and tried to use specific places that are clear, that are established to the best that we can define them, where there has been some tradition of restrictions for people with wear and carry, including in government buildings, at polling places, at power plants, places like that, and schools that we have had on the books for some time.
And that seemed to me to be the touchstone of the Bruin opinion, that you had to relate modern day restrictions upon concealed carry or use of handguns, ownership of handguns. You had to relate them back to the historic antecedents at the time of the Constitution and what our forebears several hundred years ago considered reasonable or not reasonable, and bring that into modern times. Is that a fair way to look at it?
That's what they have argued, yes. And I think that what they have also said is that there cannot be perfect historical analogs in every case, because as in different parts of the opinion, as it mentioned, that the world has changed in the last several hundred years. And in fact, firearms have changed in the last several hundred years. So they were trying to find analogs as they went up, which is why I mentioned the Third Amendment before. Is it exactly accurate? Well, no, but at the same time, it does reflect, and reflects closely, on the value that they had on personal property rights, certainly in 1789.
That's the first time I've heard of the Third Amendment since law school. I have a law partner. I was actually
Another
chuckling
thing,
when you
it's
said
another
that.
box to check on your bingo card,
Yeah,
everybody.
exactly. Third Amendment. He uses that as a
Scintilla,
parlor game
peppercorn,
sometimes when we're
scintilla,
imbibing
everybody,
beverages
again,
and asks.
Scintilla,
Yeah.
again.
Who can remember what the Third Amendment is? And everyone fails until you just said the quartering of soldiers. I appreciate it.
Peppercorn, right, thank you.
So I guess my final question is really two parts. There's also a case pending before the Fourth Circuit, not related to concealed carry per se, but related to our state's handgun qualification license scheme that has been challenged, where essentially the Fourth Circuit has not issued an opinion yet, but there seems to be some agreement among court observers that multiple judges of the Fourth Circuit believe that in fact our HQL system, by imposing all of these requirements for training and other things before you get the right to purchase a handgun, may run afoul of Bruin. Are you familiar? Your committee deals a lot with this. Are you familiar with that trend?
I've read the articles surrounding that. I guess and there is the court's main opinion in Bruin, and it's very clear that the fifth and sixth votes were Justice Kavanaugh and the Chief Justice, and you need 5. And the Chief Justice and Justice Kavanaugh were very clear in saying that there can be those restrictions on sensitive places and other public safety matters that can still apply even with the rest of the ruling in Bruin. And again, that's what we've tried to stay within in the legislation.
In light of all of this, in light of the fact that this seems to be a very heavily litigated issue, there are active court opinions out there. Are you aware, as the Attorney General of our state and their unit that operates to give us opinions or advice about the legality of bills that are being proposed, have they offered any opinions specifically with respect to SB 1 or the provisions that we're discussing for concealed carry?
I'm not aware of whether they have issued an opinion specific to SB 1, certainly not as presently drafted. Having said that, there has been there is a large amount of jurisprudence out there that is now, as you've pointed out, being crafted in different parts of the country. I believe that this legislation will add on to that. Will be part of that. It will be part of that larger discussion, and it's a discussion that I think is important for us to have. And I believe that this legislation is important for us to pass as we give the 90,000 new Marylanders who are new wear and carry holders. We try to provide a clear sense of where you can go and where you can't with a concealed carried weapon.
That's my final point in response to your question. The roughly 90,000 people who have applied and have received 100,000.
I think it's 120,000 that have applied, 90,000 who have got. I think
okay.
That's
90,000 or so who have received concealed carry permits since the Bruin decision overturned our former system of being able to sort of very, very tightly restrict those permits. Did you have any testimony in the committee from the state police? I believe the state police is still the entity that reviews the applications and grants the permit. As to, was there any kind of demographic breakdown of who was applying and receiving? Was it more women? Was it the minority community? Was it rural, urban, anything of that nature?
In fact, that was included in House Bill 824, a requirement for the state police to keep that information and to provide that information going forward. So they were able to give us numbers, but they weren't able to break it down in terms of age or gender.
Okay, thank you. I appreciate the answers to the questions. As I said, there will likely be some amendments tomorrow on third reader. Thank you.
Madam Speaker.
Gentleman from Anne Arundel.
Thank you, Madam Chair. Thank you, Madam Speaker. First and only time. Mr. Chair, good to see you.
Good afternoon.
Good afternoon. Walk me through on why I, as a property owner, have lost control of my property by asking someone to leave that has brought a firearm onto that property versus having to ask permission to enter that property or show up to that property with my firearm.
I guess the question goes to sort of a fundamental issue as to the nature of private property. And since we're all waiting for the Orioles game, let's begin a 2.5-hour conversation of that. Having said that, is that okay?
Well,
no? Okay. So anyway, so to your point, and not to make light of your point, the question I think goes to the value that we hold to private property, that is what we own, and we get to decide what people come onto our property, and whether they're invitees or anything else. We get to decide who comes onto our property, and if we don't want people to come onto our property with a concealed weapon, that's one thing. What this bill says is they have to say affirmatively, you're okay with a concealed weapon to come onto the property.
But it's my understanding in the legislation, if someone shows up with a firearm, they're in violation of this legislation.
If they show up and there is a sign that says that they are welcome with their concealed weapon, they would be able to stay on the property. If there's not a sign, they would need to either get permission from the property owner, or they would have to go and store their weapon and come back.
Okay. And also, too, and I've shut my laptop, in the bill it talks about basically spontaneous utterance on whether or not you can bring a firearm onto the property or not. What does that look like? Is that a Facebook post?
Could you repeat that? I'm sorry, a spontaneous what?
It's basically a spontaneous utterance in the bill, as far as what I understand that to be, where it talks about public notice, essentially, about you can bring a firearm to my property or you can't bring a firearm to my property.
Right.
Just for the edification of the body, and I'm sure this is going to be reviewed, that's why I'm asking these questions, the legislative intent. What does that look like and what does that mean? Is that a Facebook notification? Is that being out around a couple of people at the grocery store and you say, I don't really care. You can bring a firearm on my property or not.
We spoke to this a little bit when we defined effectively that private property, that was not a dwelling, that we defined it as, that's where you have to have a sign saying it's okay to bring that in, or you have express permission from the owner to bring it onto the property. So that's what we would require under the bill.
Great. Thank you very much.
Madam Speaker.
Gentleman from the Eastern Shore.
Thank you, Madam Speaker. Chair, would you indulge me?
Of course.
I have a couple scenarios for you. In my other life, I do a couple other things. I'm a realtor, and I work with a contractor. And as a realtor, I do open houses. Is this bill going to make me, when I do an open house, everybody comes into that open house, will I have to tell them I'm carrying?
So again, the scenario is you're a realtor, you are at the property, so you have, and it's a dwelling.
It's a dwelling.
Correct. So it's a residential dwelling. You would have permission from the property owner for you yourself, if you were yourself concealed carrying, to be in the property. Anybody else, since it is a dwelling, it would be considered a dwelling, I think, in that case. They would have to get permission to be able to wear and carry inside the property as well.
Okay, so on that same scenario where you're touching, if I go into that property, and let's say this person is an anti-gun person and doesn't like guns at all, but I'm at a property all alone. I'll use my wife because I'm a little bit bigger than she is and I can defend myself. But you go out into the Eastern Shore, we have some pretty sparsely homes and whatever. So she's out there all alone. She doesn't have anything. The person doesn't want her to carry, says, no, I don't want guns on my property. She's unprotected at that point. Is that right? She cannot carry without their express permission.
She could bring it with her, and under the legislation, and there is an amendment with storage in the car, we would perceive that she'd be able to store her gun in the car and then go into the property. But again, the question becomes, it's my property. You're asking to come into my property. Why? I guess again the question is, if it's
well, you're typically not on your property at that time. You're off the property because I don't.
Fine.
So that's going to be able to say, somebody's going to say you can't come in. I have to ask that now. Is that right?
You would have to ask the property owner or the property owner's agent. So again, in the case of you in an open house, you're then acting as the property owner's agent. They could ask you. Having said that, if you understood from the property owner that they don't want the guns in the property, you'd have a problem with the property owner at that time if you were letting people in with guns and they didn't want the people to be coming into the house with guns. So that would be a problem you'd have as an agent.
Yeah. So this will limit my ability to do business based on that, because
No.
I don't have to do that now. I don't have to go up. I don't have to notify. People don't even know I'm carrying a gun right now. You know, not right now, Madam Speaker. That's a problem. You see that, because that's not what I have to do today, and that's what I have to do to protect myself, and this will take that protection away from me. And we all know this happens. People do get hurt in homes. People showing homes do get hurt and are violated in those homes. If I lock that gun in the car, that's not doing anybody any good other than the car's safe. So that's a serious problem I don't think this thing's really taken into consideration. The other issue I have is, even with this job, if I come in here, I can't bring my gun into this body, in this building or that building. I can't have it in my car, theoretically, in that building or this building. Is that correct?
At this point, as the bill is drafted right this second, yes. However, there are conversations going on right now to address the issue of storage of a firearm in a car. That would be an exception to
In the general assembly, where my office is.
wherever, yes, wherever your car is. You're pointing the wrong way. But okay,
So
fine.
when I do walk from there, because you took away my tunnel, okay, I have to go outside in Annapolis now to come over
I
here.
did not take away your tunnel, and I resent the implications, sir.
It was nothing personal.
And it's not my fault.
Okay.
Many, many other things are my fault.
Okay. So I'm sorry to go off like that, but if I can't carry coming over from there to here, I can't carry. And you've seen out here, we've had arrests today. You saw that. Somebody gets violent. There's no way to protect me other than hopefully somebody be out there. Then what I have to do when I leave here on a Monday night, I have to then, if we're able to keep it in my car, I have to now walk back there, back to my office, down to my car. Okay, it's not stored anymore once I take it out of my car. Is that correct?
The scenario is that you've walked back to your car and you've taken it out of your car
Yes.
and you're going where?
To walk to my hotel.
To walk to your hotel?
Correct.
Under current law, you're not allowed to have it in the building at all anyway, right now. So this is, I think it would still be consistent that you wouldn't. I'm trying to get to your broader point while still sort of, this is part of the challenge, is there are some places where the law overlaps. So specifically in that case, you're still not allowed to have your firearm in the building as it stands right now. One of the things that's in the bill specific to property also, though, talks about well, it's certainly with dwellings. It talks about common spaces. So if what you're getting at is like a garage or something along those lines, and the common spaces to a residential area, I think that's covered. We also have tried to exclude the areas surrounding a building. We have added that in there as well. But if you were to take out your gun and then walk out the door and then walk to your hotel, then I believe that you would be okay.
But you're not the guy that could arrest me.
No.
Okay. Let's go back to me being a realtor, or my wife being a realtor. When I do that job, I don't just go from do an open house. I don't walk out and go do an open house. And when I'm done with that open house, I go do other things. So I'm not able to carry this, and I have to go everywhere now. I'm going to have to ask permission to do that, because stores, I have to ask a store if I can carry a gun, right?
Or they have a sign on the door of the store
saying
that
you're
indicates
welcome
that
to
you
carry.
can carry.
So as I do my job, I have to go back store, and do all those things. And I don't know the statistics, and I don't know how many cars are being stolen how many guns are being stolen out of a car today. But isn't that a little bit worse? Isn't that opening up, now I got another liability. My car needs to be locked. It needs to be secured. I got to go and actually physically do that. And that isn't typically a matter of just putting it in the back seat if I don't have it. I have to open the trunk, demonstrate that I had the gun because I pulled it out. This thing just presents a whole lot of problems for somebody like me who does carry.
So that's one of the issues for the storage within the car that we hope to address with an amendment that should be coming before us tomorrow, where the weapon would be concealed within the car in some way so that it would be less of a target. This is an issue now for people who are transporting guns. It's an issue now for people who wear and carry guns as it stands. That is not going to change necessarily under this bill, and it's going to be the same either way.
Okay, it is now, but I don't have to tell everybody I have a gun. I don't have to be aware of that. Right now, if I go into Home Depot, I'm typically allowed to have my gun on me. Anywhere I go, I'm typically allowed to do that. Under this bill, if Home Depot decides I can't, everywhere I go now that might decide that, I have to physically do that. And I think that's just an opportunity for somebody to actually look and see what I actually have in my car and actually possibly steal it. And I'm not real happy. I don't think that's a good idea. I don't think it's something I should be needing to do. I'm not I'm trained with this. I've gone through a whole lot of training to keep this thing. I guess my bottom line on the bill is I think there's a lot of limitations you're putting on people that actually have other jobs and do things that actually have earned the right to carry a gun. They have a reason to carry a gun. I carry a lot of tools. I carry a little bit of money. I just think we need to take a harder look at something like this. I'm done bugging you about all my questions. Thanks.
Gentleman from St. Mary's.
Thank you, Madam Speaker. Can the floor leader? Just a couple questions. Hey, good afternoon.
Good afternoon.
Here's the bad news. I don't have tickets for the game.
Okay. Neither do I.
Hey, I do want to explore this. I got 3 questions. And first, I did want to explore what we've been talking about. The debate's been fascinating. Over this theory that is the Third Amendment Bill of Rights, that we're using this for property. Has this ever been administered or applied anywhere else in the country?
Fortunately, no. We had the Third Amendment that was added in the Bill of Rights, obviously one of the Big Ten, but it was there, and it was a major concern for people in colonial America because of what, at the time, British soldiers were doing to invade people's homes.
Well, I guess I'm not understanding it entirely from your point of view, because right now, and I agree, the property owner has the right to remove anyone from their property. Isn't that so?
Sure.
Okay. Well, now with your bill, it gives them the right to remove anyone from their property just because they have a firearm on them. But firearms are legal by the Second Amendment. So wouldn't that put the Second and Third Amendment in conflict of each other?
Heaven forbid that ever happens in constitutional law. But having said that, here's the challenge and the question that this bill in part poses, that I have no question is going to be an issue that's addressed by the Supreme Court at some point down the line. If there was one thing that people were really, really big on during the time of colonial America and during the time that the Constitution was drafted, they were big fans of private property. Big fans of private property. Half the country were really big fans of enslaving people too, which was a big difference.
Is that in the bill? That's not in the bill,
No question,
is it?
it's not in
No.
the bill. But
Okay.
having said that,
I think that's settled law.
Yes, it's settled law. But having said that, there was a
Republican.
focus on property and the focus on what we could have and what we can't, and that government should not engage in takings, and government should not engage in doing things that would limit people's rights to
This is what this is doing. It's limiting that right, because it's legal under the Second Amendment, and now you're using the Third Amendment logic to make it illegal everywhere. Correct?
It's giving a private property owner the ability to exercise control over their property.
Which they already have.
Which they already have, and so that's fine, but in order to have that control over their property, they have to have the ability to say, I'm okay with you coming onto my property with a gun or not. And what this bill says is they have to tell people, I'm okay with you coming onto my property with a concealed weapon.
Okay. Well, I don't want to belabor
It's putting in primacy their right to property and their right to their own property.
Okay, I won't belabor that point anymore. On page 5, line 28, talks about racetracks. Racetracks defined, or is that just horse racing, auto racing?
Racetracks, I believe, were defined as, in another area of the law, to be in horse racing tracks. The idea was that we included casinos there, that we should also include the horse racing tracks.
Okay, and then my final question, same page, line 5, line 17. It says about dispensing alcohol and cannabis for on-site consumption. What is the theory there with just banning alcohol? Like you're banning the right to carry anywhere they serve cannabis or alcohol. What is the theory behind that?
Well, presently it's already illegal for people to be under the influence and be in possession of a regulated fire, of a wear and carry.
But you can be at a bar and not drinking.
Let me be clear, because I stumbled there a little bit. It is illegal for you to wear and carry a firearm if you are under the influence of alcohol. So the question again, give me your question.
So my question is just what is the theory and the reason why we're banning it in establishments with alcohol and cannabis? Because you can go to any bar or a restaurant and not drink. I mean, I just went to a restaurant at lunch and I had iced tea, but they serve alcohol. But so because of this bill, you know, I wouldn't be able to go to Galloway, or would have to store my firearm. Isn't that so?
You'd have to store your firearm. You could not take it into.
But I'm asking you, what's the theory behind that?
The theory behind that is it is a place that serves alcoholic beverages, and as such, we are drawing a bright line between the places that would serve those alcoholic beverages or cannabis, if that happens, or not.
But maybe the logic is just completely 180 degrees different than what I'm thinking, because I think the logic you're saying is because there's alcohol and cannabis served at these establishments, there's a bigger chance for stuff to go awry and violence to break out and someone's armed. In my opinion, if that's true, and I believe most people believe it's true, I mean, that should be the first place that you carry because that's where you would defend yourself, correct?
I think it is the place, conversely, that you would want to make sure that people were not concealed carrying because it is far more common for people to get involved with violence at those places.
So I'm out to lunch with my family. Somebody's having a little bit too much to drink and it gets out of hand. Maybe something's going on. I'm not allowed to defend myself, or my wife's not allowed to defend herself simply because she was going out to lunch at a restaurant. So she's checking her Second Amendment rights at the restaurant. Is that the theory?
What the bill says, again, is that if it is a place that is licensed to serve alcohol or to allow for the consumption of cannabis, that you would not be able to concealed carry at those places unless you met one of the exceptions in the bill.
Well, we'll take it up on third read. I appreciate your compliments.
Madam Speaker.
Yes. Just a minute. Gentlelady from Carroll.
Thank you, Madam Speaker. Just had a question from earlier. So on page 4, starting at line 17, it says, areas for children and vulnerable adults means a preschool or pre-kindergarten facility or the grounds of the facility, a private primary or secondary school or the grounds of the school. So my question is, I think it was stated earlier, you may carry in churches, correct?
Yes.
But you can't have it at a school. So what if that church also has a school or a daycare on the property?
The private school is also included, a private primary or secondary school, and that would include parochial schools. So they would not be able to wear and carry unless they met one of the exceptions in the bill.
But if you're going to the church and you have to walk through a hallway or an area where there is a school or a preschool, do you then become a criminal because you are technically in a school for 5 minutes that it takes to walk through that facility to get to the sanctuary?
I believe that, to your point, what the committee believes is you're going to the church, then you're going to the church and you have the ability to carry in the church. Then I don't think that would apply, but having said that, that's one of the issues that the committee has taken up and gone back and forth, and there are different situations at different places across the state. So we've tried, however, to create as many bright lines as we can in the bill.
Right, I think it's
But at the same time, we cannot draft a piece of legislation for every single church-school combination across the state either, and that's part of the challenge.
I would agree, and I think that's why this bill is so problematic, because, and really not helpful and not needed. And I think, just to echo what my delegate from Cecil County just shared, we're going to make a lot of people who have gone through extensive training to be lawful owners and carriers of their firearms after spending a lot of money and going through. I've gone through it myself. My concealed carry permit is hopefully waiting for me in the mail at home. So I know personally how much training, how much school training that we had, hands-on training, and the cost involved with all of this. And people are not going through all of that willy-nilly. If they want to commit a bad crime, they're just going to get a gun and go and do it. And I think that, when you have all these questions in so many areas, and you say that would be a long hallway or would take a long time, I've been in a lot of situations where there's a church somewhere within that building where the actual church service happens, yet there are hallways filled with classrooms that you would have to walk through. There's nurseries. Churches provide nurseries. So if you want your gun with you in church, but you have to take your child to the nursery that's in the same building, you're going to have parents who are now suddenly criminals.
The bill seeks to identify those places that are sensitive places where we don't want people to be carrying a concealed firearm. And I know that this is another issue that has come up in front of the committee, and one of the things that we believe that we've tried to draw as clear a line as we can to say that you cannot go into a school, but we didn't touch a church, and the question about what is going to be a question that would be left to the courts at this point.
I appreciate your answer, and thank you for taking the time.
Gentleman from Baltimore County.
Thank you, Madam Speaker. I had a few questions. One is, it has to be express permission. Does that have to be in writing?
It has to be express permission, and that would be something, I think it would be easier to prove if it were in writing, to be sure, but it would have to be express permission from the property owner.
Okay, because I have some concerns with that. If I ask you permission, if I can come in your house and I have a gun, and all of a sudden you get mad at me, you say, no, you're getting out, I'm going to call the police because you have a gun in my house. How is that going to affect?
That would be investigated, and you'd have to find. I mean, I guess the question there would be a question at that point whether the person had given you the express permission or not, and if you had acted based on there being that express permission that was given, then you would be covered under the exception of the bill.
Okay. The other question I have, I just wanted to segue off of my delegate friend in the back that's a realtor. I'm a real estate broker. We go into empty houses a lot of times. We might show 8, 10 houses at a time. How do we deal with this when we're going into an empty house? Do we have to get each and every owner to give us permission to go into an empty house?
The property owner or the property owner's agent would need to give you permission. If it were a vacant house, then you would, presumably being the agent of the owner, you would be able to give yourself permission in that case.
Well, the problem is, if you're a buyer's agent, you actually work for the buyer. So you're not
You would need it's the owner of the property. So if you're buying the property, you would have to get the permission of the owner of the property at that time.
Right. But what I'm saying is, if you're a buyer's agent, then you would have to get each house that you're showing permission to go into that house.
Yes.
Am I correct? Okay. What about can the state override federal laws as far as property rights and things of that nature?
Can the state override federal? The state, as I would read it, could build on top of, but could not contradict with federal rights with regard to property.
Okay, because we go into a lot of HUD houses, and how do we deal with that if we have a concealed wear permit and we're going into a HUD house or a VA house or one of these houses? So
it would depend on, you would have to have the authority that came from whoever the agent was or the owner of the property, but I think in that case the agent of the property would have to provide permission for you to be able to go into the house.
Okay, I hate to bewilder this, but what about bank-owned properties?
You'd have to get the permission of the agent of the owner or the owner, so in that case either the bank or the bank's agent, to be able to go in to the property and wear and carry.
Right. Well, a lot of times these banks, they trade back and forth, and a lot of times we don't know who owns them.
You know, that's a big challenge, and one of the big challenges that I see in my district quite a bit. It's not quite on the bill, but it is one of the challenges we have, tracking down some of the banks who transfer these things all over the place. So I do accept that, but at the same time, if they're seeking to sell the property, they've hired an agent to do that, and so you'd have to ask the agent whether you have permission to go into the property with a concealed carry weapon.
Right, well, a lot of times these banks aren't represented by agents. It's just, there are different ways they're handled. I thank you for your consideration. I do have a couple more questions. What has changed since June 23rd of 2022, since the Brewer? What has changed? Why do we have this bill?
We have the bill because the Bruin decision said that we had to have objective rules and an objective criteria that addressed people's ability to wear and carry concealed weapons in public.
Okay. And you previously stated that there was over 120,000 people applied for gun permits. Am I correct?
Since Bruin, yes.
Okay. And if I'm correct, 90,000 of them were permitted?
That's my understanding, yes.
Okay. So apparently 30,000 people didn't get them. So is that saying that the system's working with the background checks and the training and everything?
I believe that's showing that those 30,000 people didn't qualify, yes.
Okay. So the system is working with the state police right now?
Sure.
Okay. Let me put my glasses on. Sorry about that. Can I ask you that question? You know, the problem that I have, I'm a real estate broker. My daughter's a real estate agent. My daughter weighs 105 pounds, maybe wet, stands about 4 foot tall. A lot of times we go into these houses, we don't know what we're walking into. I've walked into houses that they've been squatters, especially in Baltimore City, some parts of the city. You might walk into a HUD house that people are living there. And I mean, it's so bad they use the toilet, I mean, they use the bathtub as a toilet. I've seen this. And, you know, going into some of these houses, you know, I always tell my daughter, make sure you take somebody with you if you can, but a lot of times you can't, especially if you're out showing 10, 15 houses at a time. It's hard. So how are you going to, you know, if you're showing 8, 10 houses, how are you going to express permission for each one of those houses and keep record of that? The paperwork just seems mind-boggling.
Presumably, if you're going to the houses to check upon buying the houses, you've made contact with the people who are selling the houses. And if you've made contact with the people who are selling the houses, you have to, at that point, ask them, is it okay if I have my concealed carry permit, my concealed carry weapon with me? It would be a question that you ask the person that you're seeking to purchase the property from.
Right. Well,
is that onerous?
It's a HUD home. If it's a HUD home, it could be through several different agencies. Sometimes it's hard to figure out who's actually maintaining management of the house. And that's who we have to talk to a lot of times.
But ultimately, you find the person who has the management authority of the house, right?
Not all the time, because we can actually go online. If a HUD house is listed, we can actually go out and show that because we have a key. So we don't have to get permission. We can just use a pass key and go in and see it. Same with a VA house and a bank-owned property.
You would get a code to get the key and then be able to go in the house, right? So you find out how to get into the house from somebody, right?
No, we actually...
You don't just randomly go to houses and...
No, we're actually given a key from HUD to enter these homes. So
from somebody. Somebody gives you a key to go into the house, and you don't think you could ask that person who clearly has authority over the key to give you to go into the house whether it's okay or not?
No, it's a master key. HUD issues us a master key that we can go into any HUD house and sell that or show it. And that's where I guess we're going to have to kind of look through this. A lot of times as a real estate broker, we have to collect rent, handle cash. Would we still have to get permission from the people that we're picking up rent from, the owner, or the people that have the house?
If you're not going inside, no. If you were going inside the house, you're still the owner of the house in that case, and so I think there's a distinction there. But right. Having said that,
well, no, I'm not saying me as the owner, but me as the agent picking up the rent as, you know, property manager or something of that nature. And a lot of times they're owned by corporations, and we're just, you know.
You're an agent of the owner in that case, so you'd be fine.
I'll have to give that some thought. That's a good question. Anyway, I want to thank you for thank you for that.
Thank you.
Madam Speaker.
Gentlelady from Frederick.
Thank you, Madam Speaker. So I will try to keep this very quick, even though I'm really not known for that, but I'm going to try. If one homeowner gives permission and the other does not, what happens in that situation? Like my husband and I own our house together, and say he's more pro-gun than I am. We have a lot of people that ask to come and hunt on our land and things like that, and I might get really mad about that and say, no, I don't want you to.
First of all, it wouldn't apply to the land surrounding it. It would apply to the building itself.
It would, because we camp on our land.
Well, okay, but I understand that. The law or the bill as it's stated right here is that it's the owner or the owner's agent who would have to give permission.
We're both owners, so they would have permission, and even though I didn't want them there, they would be able to stay?
If you didn't want them to concealed carry on the property, then if there was somebody who said no, I think the default would be no.
Okay. And then how does it apply to apartment buildings?
The apartment buildings, there's a section in the legislation that deals with apartment buildings. The common areas are distinct from the apartments or condominiums themselves. So the condominiums effectively become the dwelling.
So what about the common areas?
And going through the common areas, all of the easements, people would be able, if they were legally able to wear and carry, they'd be able to go through those areas.
Regardless of what the owner of the apartment building desired?
The question that question actually came up in front of the committee, and I'm going back to the dwelling does not include common elements of a condominium as defined in the real property article, property of a cooperative housing corporation other than a unit defined in the corporations and associations article, or common areas of a multifamily dwelling as defined in the public safety article.
So they'd be okay even if they didn't want them?
That's my understanding. If there was if beforehand you would also know if you lived in that property whether it would be allowed or not in the lease provisions. In theory, the property owner could say that the whole building could say that people could not concealed carry in theory. But I think that the reality is you'd be able to concealed carry, as I read the statute, you'd still be able to concealed carry in order to get to your own personal dwelling. So you'd be able to go through those common areas. So I don't think that actually would apply now that I think about that.
I'm very confused
end of the day, you
law.
can go through the common areas in order to get to your condominium or your apartment.
Okay, what about your guests?
Your guests would need permission to go into your condominium or apartment. Whether they would have the ability to go through common areas would be dependent on the property owner of those common areas, so the landlord or the condominium association as a whole.
So before I had someone over who concealed carry, they would have to contact the building owner, which we have no idea who that is, to get permission to walk to my condo.
First, again, they would need to have permission to be able to go to your.
Well, yeah, I invited them over.
That's fine.
Yeah.
I'm gonna get you an answer because we don't deal with this part of real property law in the committee.
Okay.
We'll get you an answer for that part of it. That is an important question, and we'll get you an answer to that part.
Thank you. I agree. And these are the kinds of questions that we're getting from people. My last concern is very difficult. It's about protective orders, and particularly with women, particularly with domestic violence, particularly if they have been assaulted or attacked or even threatened, or if they've been stalked. That is of utmost concern to a lot of women here. I have been in situations even since I started here where there have been very uncomfortable situations where having a concealed carry permit definitely crossed my mind as far as being able to defend myself. I can't even bring my mace into the State House here. So that makes me very vulnerable when I leave certain areas. And it doesn't just apply to here, but even me as a 50-some-year-old woman, I am uncomfortable walking at night by myself and not being able to protect myself, particularly if I had had or been a victim of domestic assault and I have a protective order, especially if I'm a young mom, if I'm a young girl who has a stalker. So what has been put in this law to allow young women, girls, or anyone else who has been a victim or under threat of being a victim to be able to protect themselves?
As the law stands right now, you could apply for a wear and carry permit. You could apply for a wear and carry permit, and what this law says, what the bill says, is that there are certain places that you're not going to be able to wear and carry, and they are consistent with places that we have not allowed people to wear and carry for quite a while. They include schools and government buildings. They include power plants and other establishments. That's what this legislation does. It does not go into a question as to whether or not a person who has been the subject of a protective order should have a special pathway to getting a wear and carry permit. That's beyond the scope of the bill. This deals specifically with the places where you cannot carry a firearm under the wear and carry statute.
Which are being very drastically expanded.
I would say that government buildings are already covered to some degree, including the one that we're in right now. I would say that schools, public schools, were already covered. We have expanded it, I believe, into the area of a stadium. But if you've gone to M&T Bank Stadium, you see the metal detectors there. Some portion of the body also hopes to see metal detectors in perhaps a little less than an hour and a half or so at Oriole Park. It expands it to some more places, but the goal here was to provide for very specific places like hospitals and schools and government buildings where we have traditionally said that people should not wear and carry concealed weapons.
So just, I don't want to belabor this because I do have an amendment. So no consideration was given under the list where a person with a protective order against them should be allowed more freedoms, as their abuser would know specifically where they're going to not be able to have their weapon on them, which would leave them more vulnerable.
One of the challenges in prosecuting domestic violence cases for some time, one of the challenges in domestic violence cases, and particularly as it relates to protective orders and peace orders taken out in those cases, is it is fairly common for a person who would later be found to be the abuser to take out a protective order against the other party. And so the challenge with drafting an amendment along those lines, if the question is that it should exclude the victim of domestic violence, if that is somebody who is the subject of a protective order, that could be both sides in the dispute. And there are plenty of studies, including one that I'm happy to forward, that we see the uses of firearms happen more commonly in these kinds of disputes. So one of the things we sought to avoid was to create situations like that by creating sort of broad-based, and I get that it sounds unsympathetic. It sounds entirely unsympathetic to say that victims should not be able to get that special protection. The problem that we have as the law is drafted, and the problem that we have in how these laws are used in domestic violence cases, is that we have both sides who will take out protective orders against each other. And in many cases, both sides will have those granted. So under at least one of the amendments I saw, one of the challenges you could have is, okay, well now we've carved both sides out. They already don't like each other very well. They really don't like each other because there are threats of violence on both sides. So let's give both of them a gun and see what happens next. That's effectively what carving domestic violence cases out of this would do. It could put more people at risk, not less.
So women being able to protect themselves or any victim of partner violence. You're saying because someone else might have a gun as well, even though that's what's happening now.
I'm saying that because both sides can take out, again, you need an objective standard to say, these are the people who would now be able to wear and carry in this specific situation. And the problem is, in that specific situation, multiple people could take out a protective order. In the example that you said, if you were the person who took out a protective order on another person, you would be the person who would then be able to get protection if I heard what you would want to do. The problem with that is if both sides do that, you're making it possible for both sides now to be in possession, and that I think creates more problems. And furthermore, once somebody has a protective order, this is also true, they actually have to surrender all of their weapons in the first place. So it becomes a bit of a feedback loop to say, let's carve that out into the statute and create an even greater problem.
Okay, well, happy to finish this tomorrow.
Sure.
Thank you. Thank you very much.
Thank you.
Madam Speaker.
Yes, gentleman from Western Maryland.
Thank you, Madam Speaker. If I could ask you a couple questions. I had no intention of asking questions on this, but it seems like the longer we go, the more confusing it gets. I saw there's a lot of language in here about police officers, retired police officers, but what about other folks of presumed risk, like judges and prosecutors? I believe I saw language where if they're within the confines of their building, they can kind of set their own rules.
The judiciary asked for an amendment, and an amendment was added in that allows the judiciary to set its own rules with regard to the people who can possess and cannot possess within the courthouse.
Okay, so what about those same folks with presumed risk when they leave that building? They go to the grocery store, they go to daycare, they go to a baseball game, whatever. Are they allowed to carry in those places, or are they at risk if they're not allowed to carry?
If they had a wear and carry permit, they would be still subject to the rules and to the exclusions that are in the legislation.
So they would be subject to all those same rules as anyone else. There's no carve out for them
They
for
would
protection.
be correct.
Okay. Yes. And then I was a little confused on your answer with the prior delegate. Did you make the statement that a landlord can override a tenant's ability to carry a gun or to keep a gun within their rented apartment or house? I thought you said that the owner of the building, the landlord, can stipulate whether or not you can have a gun.
I believe that I misspoke in that case. I believe that what we have said in the bill is that somebody who has a dwelling has the ability to allow people to come in and wear carry. There's nothing in the bill that seeks to limit a person's ability to possess a firearm inside their own home. And multifamily dwellings are excluded under the bill.
And that includes a tenant. So in that case, a tenant would have the ability to say whether or not they can own a gun or keep a gun inside of that home, not the landlord. What if the landlord says no guns, but the tenant owns a gun? I'm confused on who has.
If, as it's drafted right now, if the landlord said, your question is if the landlord says that they cannot have cannot wear and carry.
What if the owner of the building, the landlord, says no guns?
If the owner of the building says no guns, again, under the bill, that would be the owner of the property's choice to determine whether or not there were those firearms or not. And the person, if they wanted to possess a firearm, would go to another place where they could possess a regulated firearm in that case.
Wow, okay. And if it's silent, if their rental agreement is silent on that, the landlord hasn't expressed an opinion, can that individual then keep a gun inside of their apartment, or does it default to the other language that says you can have a
They would
gun?
be fine, yes.
You would be fine?
Yes.
Okay, thank you.
Is there any further debate? If not, Senate Bill 1 is ordered past the third reading. Message from the Senate, House Bill 98. The clerk will read the bill.
House Bill 98, condominiums, mandatory insurance coverage, alterations, amendment number 1.
The clerk will read the message from the Senate.
Ladies and gentlemen of the House of Delegates, the Senate does not proceed in the Senate amendments and agrees to a conference committee to confer on the disagreeing votes of the two houses. The House has appointed Delegate Holmes, Chair, Delegate Lehman, and Delegate Baker. The Senate appoints Senator West, Chair, Senator James, and Senator Kelly. Said bill is returned herewith.
Message from the Senate, House Bill 214. The clerk will read the bill.
House Bill 214, Commission on Public Health Establishment, amendment number 1.
The clerk will read the message from the Senate.
Ladies and gentlemen of the House of Delegates, the Senate does not proceed in the Senate amendments and agrees to a conference committee to confer the disagreeing votes of the two houses. The House has appointed Delegate Bagnall, Chair, Delegate Rosenberg, and Delegate Kipke. The Senate appoints Senator Lamb, Chair, Senator Ellis, and Senator Reedy. Said bill is returned herewith.
Message from the Senate. House, the clerk will read the bill.
House Bill 471, Economic Development, Regional Institution, Strategic Enterprise Zone Program, Alterations and Financing, amendment number 1.
Clerk will read the message from the Senate.
Ladies and gentlemen of the House of Delegates, the Senate does not proceed in the Senate amendments and agrees to a conference committee to confer the disagreeing votes of the two houses. The House has appointed Delegate Palakovich-Carr, Chair, Delegate Hartman, and Delegate Vogel. The Senate appoints Senator Elfreth, Chair, Senator Quarterman, and Senator Zucker. Said bill is returned herewith.
Messages, House Bill 374. The clerk will read the bill.
House Bill 374, Health Insurance Pharmacy Benefits Managers, Audits of Pharmacies and Pharmacists, amendment number 1.
The clerk will read the message from the Senate.
Ladies and gentlemen of the House of Delegates, the Senate does not proceed in the Senate amendments. The Senate respectfully requests the House reconsider and concur. Said bill is returned herewith.
The clerk will read the message to the Senate.
Ladies and gentlemen of the Senate, the House of Delegates refuse to concur in the Senate amendments and respectfully request the Senate receive from its position. Should the Senate prefer a conference committee to confer on the disagreeing votes of the two houses, the House appoints Delegate Cullison, Chair, Delegate Hill, and Delegate M. Morgan. Said bill is returned herewith.
That ends the work at the desk. Committee announcements, appropriations.
Thank you, Madam Speaker. The Appropriations Committee will not meet after session today.
Judiciary.
Thank you, thank you, Madam Speaker, ladies and gentlemen of the House. The House Judiciary Committee will have a voting session tomorrow morning at 9 a.m.
Environment and Transportation.
Thank you, Madam Speaker. The Environment and Transportation Committee will not meet today.
Ways and Means.
Thank you, Madam Speaker. The Ways and Means Committee will not meet today.
Economic Matters.
Thank you, Madam Speaker. The House Economic Matters Committee will not be meeting today.
Health and Government Operations.
Thank you, Madam Speaker. The Health and Government Operations Committee will not be meeting today, but we will meet in the morning at 9 a.m. for a voting session. Thank you.
Okay.
Madam Speaker. Apologize.
Yes.
I
Appropriations.
neglected to, we will be voting and have a bill hearing tomorrow morning at 9 a.m.
At 9 a.m. Okay. I assume there's no subcommittee announcements. Skip the rules.
Thank you, Madam Speaker. The Rules Committee will be meeting tomorrow morning, 15 minutes before session, in the old House chamber. Thank you.
Okay. I assume there are no subcommittee announcements. Delegation announcement. Caucus announcements.
Madam Speaker.
Who's calling? Chair of the Chairwoman of the Black Caucus.
Thank you, Madam Speaker. Colleagues, if I could just have your attention for about a minute or two. Madam Speaker, in my 7 years as a member of this House, we've had a lot of disagreements on this House floor. Just today, we debated one of the toughest issues that we face, gun rights. And earlier this week, we had a really heated debate when it came to delegation concerns and delegation courtesy. But it's because of our passions and our deep beliefs that sometimes we spar and sometimes we have these heated conversations. But there is never a doubt in my mind, not even an ounce, that every single member of this chamber is acting on behalf of their constituents and their beliefs, regardless of if we agree or not. I'm proud that in this chamber, We fiercely defend our decorum and our rules. And sometimes when a member goes too far, we take action on this floor to call each other out and to stand up and ensure that our rules and our decorum are being protected. Although our rules and the foundation of legislative procedure say that the majority must prevail, we respect and give protections to the rights of the minority in this chamber. We are 141 people representing distinct communities with different viewpoints, but the ability of us to conduct business in this House, it relies on fairness and due process. Colleagues, sometimes there are actions that take place in other states that really impact us here and all across the country. And I rise because the members of the Legislative Black Caucus of Maryland are stunned by the actions that have taken place in Tennessee. And on behalf of the Legislative Black Caucus of Maryland, I rise to stand with our colleagues in Tennessee. I rise to remind us of how delicate the fabric of this body is, and how we must always work to defend and protect each other and ensure that there's fairness and due process for everyone. So colleagues, I appreciate your indulgence, and we have Tennessee on our minds and in our hearts as we continue the work of the people. Thank you.
Any other personal or guest announcements? Gentleman from Baltimore County.
Madam Speaker, I know we all want to go to the baseball game, but I would be remiss. I have my daughter and my soon-to-be son-in-law. They happen to be here. Please rise if you would. Aaron and Natalie. Now, go O's.
Madam Speaker?
Yes.
I'd like to revise what I had to say. I'd like for the Environment and Transportation Committee to meet in the committee room tomorrow morning at 9:30 in case we have some work to deal with. Thank you, Madam Speaker.
Okay. Caucus Chair.
Oh, thank you, Madam Speaker. This is a personal guest announcement.
Oh, personal guest announcement.
Thank you,
Okay.
Madam Speaker. Just want to recognize our wonderful former colleague, Prince George's County Councilwoman Monica Fisher.
Okay. Any other personal or guest announcements? Quorum call before adjournment.
Madam Speaker.
Has everyone recorded their presence? Clerk will take the call. There being 137 members present, the House is still in session, recognizing the majority leader.
Thank you, Madam Speaker. I move the House stands adjourned until Saturday, April 8th at 10 a.m., Legislative Day, March 30th. Play ball.